So just as usual, I just want to flag before we start that, we never know what people's experiences have been with mental health difficulties. We don't know how upsetting or triggering conversations can be, or information can be. So just always, our priority in mental health reform is that you look after yourselves. If you need to step away, please do. If you want to log off, please do. There are supports out there, and your well-being is our priority. So please that do keep that in mind for during the session. So I'm going to stop sharing there for a second. So just to say as well, so it's a safe space. Step away if you need to. Just to say, we've been having some technical issues already in our tech check this morning, so please bear with us. We've been trying our best. Huge thank you to our speakers this morning. I'll introduce each. This is basically, the aim of this is an information giving session, and there's lots of signposting for places where you can find more information, and hopefully we'll have we have some questions that have been in already. Huge thank you to Sarah and Catherine, our ISL interpreters this morning. Really delighted to have them here. And yeah, we'll please, at the moment during the presentation, don't share the slides more widely. The slides were made available yesterday for accessibility. It's best practice for accessibility to share as much information before a session as possible. But we will link in with the speakers. Yeah, Catherine?
Bernadette, I'm so sorry. I've got 3 messages saying that there's people in the audience that cannot see the interpreter.
Okay. Niamh?
Sorry about that.
No. Oh yeah, sorry, I can see it here. So just on your view screen, our ISL interpreters are spotlighted. So in the top right hand corner, if you go to view and then click on speaker, you should be able to see me and Sarah, who's interpreting at the moment, and Catherine. And when the presentation starts, there will be the presenter, the ISL interpreter, and the PowerPoint presentation. So actually, Niamh, I'm not sure, can you answer those questions in the Q&A function?
Yeah, no problem. I'll just put that into the Q&A now. Thank you, Bert.
So because we've a packed schedule, I'm going to hand over to Anya now. Anya Flynn is the Director of the Decision Support Service, and Anya is going to share her presentation with us. And Sarah will be with us for about another 10 minutes, and then we'll switch over to Catherine. So thank you so much, Anya, for being here with us this morning. Thank you.
Thanks very much, Ber, and thanks to Mental Health Reform for the invitation to speak to you all this morning, and it's really encouraging to see so many people present. Let me try to share my screen. And in the hope that somebody will shout if this isn't working. So far so good, I think. So the Assisted Decision Making Capacity Act, and how does it interact with mental health? What's new, what's changing, what's staying the same? So as Bera said, this presentation takes about half an hour, and I'd hope to cover the areas which I think might matter to you. So and I hope that slide has changed, a little in the dark here, but I'm sure somebody will tell me if functionality isn't what it needs to be. So the Assisted Decision Making Capacity Act is law already, signed into law right at the end of 2015, and that was after a very long lead time. I think it improved along the journey with the input, the really valuable input from various NGOs and DPOs and so on, but it hasn't yet fully been commenced. Now, we do now have the date. Just a couple of weeks ago, Minister O'Gorman, Minister for Children, Equality, Disability, Integration and Youth, named the day when everything comes to life. That's the 26th of April next. So we are just about 7 weeks away, 7 weeks tomorrow, I believe, from full commencement. That's when the Act will begin to be fully operational, and we in the Decision Support Service also begin to deliver on all of our functions. One change in recent times has been that the amending legislation made its way through finally being signed into law by the President on the 17th of December. So that's the Assisted Decision Making (Capacity) Amendment Act. And whilst I'll refer to it in bits and pieces as I go along, that act, although it's long enough, it didn't change much that is core to the original legislation. So the position with regard to capacity, the guiding principles, and the essentials of the new framework for support are all unchanged. And these are the key reforms which the original Act introduces. So we see the abolition of wardship for adults under the old Lunacy Regulation Ireland Act of 1871. So no new applications for wardship after the 26th of April. And everybody who is a ward will be coming out of wardship. All adult wards will have their cases reviewed under Part 6 of the Act and will be discharged from wardship, and that must happen within 3 years. Those wards simply have their property and their full decision-making autonomy returned to them, or the wardship court may find that they should move over to one of the new forms of support. I know that some questions have come in advance about wardship, so just a couple of things to say there. There is an amendment which means that if an application is current at the moment, if it has been lodged before the 26th of April, then that may continue its course after the 26th of April and orders in wardship may be made, or the person may move over to the parallel line to the new supports under the 2015 Act. And also to say about Part 6, that's being managed by the Office of the Wards of Court and the Wardship Court. We in the Decision Support Service aren't directly involved there. So if anyone needs more information about that, the Office of the Wards of Court has been doing communications to current wards, their committees and their families, and you can contact the Office of the Wards of Court, or we in the Decision Support Service can point you in the right direction. I'll be saying a little bit later on about Part 10, which makes provision for the minority of wards who are detained at the moment in wardship. So in total, there are about 2,200 adult wards of court. And as I was saying, all of them are coming out of wardship. Just very briefly, the Act repealed also an even more antique bit of law, which said that wards of court couldn't get married. So that's the Marriage of Lunatics Act, a shameful title. The Marriage of Lunatics Act of 1811 said you couldn't get married if you were a ward of court. And that has changed already more than 2 years ago in February of 2021. That was effectively repealed. I'll move through the rest of the key reforms over the coming slides. The functional assessment of capacity, the statutory guiding principles that apply under the Act, the new 3-tier framework for support, tools for advanced planning, and I'll also say what we do in the Decision Support Service. Now, thinking about the particular interaction with mental health, I think it's important to say that the 2015 Act doesn't touch the Mental Health Acts, as they're called, the Mental Health Acts of 2001 to 2008. Separately, a Mental Health Amendment Bill has begun its journey. There were heads of bill published last year, and there has been a commitment from government that the mental health bill is to be prioritised this year. So that's with the Department of Health at the moment. And this Act, the 15 Act, belongs to the Department of Children, Equality, Disability, Integration and Youth. We in the DSS, in case it needs saying, didn't write the legislation. We were allowed input a bit as it was being further developed and amended, won some arguments, lost some others, but obviously responsibility for legislation and how it's put together is with government. Okay, the functional assessment of capacity. So Section 3 of the Act states that a person's capacity shall be assessed on the basis of ability to understand at the time that a decision is to be made, the nature and consequences of the decision in the context of available choices. So a time-specific and issue-specific test. If you're familiar with how wardship is applied, in wardship, a person can be found to be a person of unsound mind. It's sometimes been described as a badge or a status approach, and it has been criticised pretty broadly as being a blunt instrument because, well, very often people are taken into wardship for a significant purpose, a big piece of decision making, but the effect of being made that ward of court is that your entitlement to make your decisions in relation to unrelated and even quite minor matters devolves away from you and goes to the court. And the idea with this Act and the way that the framework for supports is set up, that it's as much support as you need and that capacity is always relative to a particular decision. Another important point, I think, about how capacity is formulated with this Act is that it isn't a medical test. So when you look at this definition, there's no kind of diagnostic criteria or threshold. It's been demedicalized, if you like. No link is being made between a person's decision-making capacity and their cognitive ability. So the fact that a person has an acquired brain injury, enduring mental illness, intellectual disability, none of that is called out and is of relevance only if it's actually impacting on decision making. So that a person lacks capacity, thinking always about the particular decision to be taken. A person lacks capacity if unable to understand the relevant information, retain that information for long enough to make a voluntary choice, weigh up and use the information and communicate a decision. And that's communicate with appropriate assistance if necessary. So the fact that a person requires sign language or assistive technology or simply the good support of the person who knows them best and knows how they communicate, that's no indication of a lack of capacity, and those tools to support communication should always be made available. And I'm saying here that this is a statutory approach. And by the word statutory, I mean that it is being put into black letter statute law, but in fact, it is already the position at common law, in other words, judge-made law, because we have two ways of making law in this country. It can either be by legislation that comes through the Oireachtas, or it can come from the courts. So this approach to capacity was already set out by our courts as long ago as 2008, when the High Court set out a test pretty well like the one you see here with the 4 parts to it. And the functional approach has already been adopted for many years in various policy and standards documents, including the HSE National Consent Policy, which has recently been revised and reissued, and Irish Medical Council guidelines, so very much with us already. And these are some of the important guiding principles under the Act at Section 8. And we see, first of all, the presumption of capacity for adults. The Act, I should say, applies only to those over the age of 18. There has been some commentary that 16 and 17-year-olds should also have been considered, and perhaps that will change with time. For the moment, it is for 18-year-olds and over. So adults are presumed to have capacity to make a particular decision unless and until the contrary is shown. And if shown, that would mean shown in that functional way that we've just looked at. And this, like the functional test itself, is already with us at common law. It's already true that any adult is presumed to have capacity to make a decision. Is that always honoured in practice? You might wonder. I know I was consulted about a case, it goes back a while, where a woman had been presenting regularly for a particular healthcare intervention, and separately she was receiving mental health supports and had been on a particular medication, and she had come off that particular medication, and when she presented thereafter for another one of these healthcare treatments, she was disclosed that she'd come off her mood stabilizer or whatever medication it was. They said, well, then we're just not going to treat you today because we don't know about your capacity and we have neither the time nor the training to assess you. So clearly a presumption of incapacity was applied in that case, and that's not acceptable. Persons must be supported to make their own decisions as far as possible, and I do think the Act is strong on this. The starting point isn't at all that you get into assessing a person's capacity. I often point to the brackets around capacity in the title of the Act. Rather, this is an Act about supporting people as far as possible to exercise their decision-making autonomy, and you would only get into the business of assessing capacity or looking to formal supports where that hasn't been possible. An unwise decision doesn't mean that the person lacks capacity, not quite the same thing as saying that people have an unlimited right to do unwise things. But what the Act says is that wanting to do the unwise thing doesn't mean that you lack capacity to decide to do it. There would have to be further evidence of that. And I think the Act is quite strong in the next points, which are very much taking their cue from the United Nations Convention on the Rights of Persons with Disabilities, ratified 5 years ago today. Is it today? Yeah, anniversary. So Ireland ratified the UN Convention in spring of 2018. And a lot of the guiding principles are inspired by the language of the convention, where we see the emphasis on doing the least restrictive thing, minimal restriction of rights and freedom of action, the importance of respect for dignity, bodily integrity, privacy, autonomy, the right to control over your own affairs, the importance of a participatory model of decision making, permitting and encouraging the person to participate as fully as possible in the intervention that concerns them. And I've put the next one in bold, please, because it's next one in bold because it is considered to be at the heart again of the UN Convention, and really is the golden thread that runs throughout the 2015 Act, where you see various references to the importance of a person's will and preferences. At the same time, acting always in good faith and for the benefit of the person, but nowhere in the Act is there a reference to best interests. You'll know that best interests is the familiar standard in other pieces of legislation, including in the Mental Health Act as it is at the moment. And that's something which we hope will be changed when the Mental Health Act goes through its amendment. Yeah, I should say that when Ireland ratified the UN Convention, it did so with a reservation and declaration so that Ireland retains substitute decision making as a last resort and subject to safeguards. So that's the top tier of support, and I'll come to it and to the safeguards that apply. Well, what decisions may be supported? So if this is the Assisted Decision Making Capacity Act, what decisions can be assisted? And they're divided into two categories. So we see property and affairs decisions and personal welfare decisions. On the property and affairs side, anything really to do with your money and what you own, also applying for benefits, supporting other people, paying debts, being involved in court proceedings if they arise. And then on the personal welfare side, decisions around accommodation, including residency in a designated centre, education and training, social services, healthcare, which would include medical decision making, and other matters relating to the relevant person's well-being. There are certain limited exceptions spelled out in the later section of the Act where the existing law on capacity or consent is unaffected. But unless specifically disapplied, this is an Act which applies in many settings. So I've spoken to the prison service, for example. I speak to banks, all sorts of healthcare professionals and legal professionals. This is the Act which has this broad application across many settings and included in mental health services settings, unless it's specifically disapplied. And I'll come to the small exceptions where that is true later on in this presentation. This is the new support framework then. So there are three different tiers. So you see at the lowest level, the decision-making assistant, co-decision-making in the middle, and then at the top tier, that retained model of substitute decision-making, which can be put in place by the court, the decision-making representative. And there are eligibility criteria across all of these tiers so that nobody could become one of these decision supporters, as we call them, if they have, for example, certain previous convictions, family court orders, barring orders and safety orders. And if the person is in residential services, then the owner or the registered provider or an employee of that service isn't eligible to become one of these supporters, the idea being that there could be a conflict of interest. And all have to apply the guiding principles, including that all-important respect for will and preferences. So briefly, I'll go through each of them. At the lowest and least formal tier, you see the decision-making assistant. And sometimes we're asked in the DSS, well, how do I become my person's decision-making assistant? And it's really important to remember that that has to be the choice of the person who considers that his or her capacity is or may soon be in question, is choosing somebody whom they know and trust who's going to step into this quite light touch supporting role. And then they put in place a decision-making assistance agreement, setting out those particular decisions that will be amenable to that arrangement. And the decision-making assistant then has these functions and duties to assist in the gathering up of information, explaining the information, helping the person called here the appointer to communicate what they want to do, helping them to make and express their decisions and to ensure that those decisions are implemented. So it could be decisions about healthcare. And here is somebody who is authorised to be part of that information sharing, part of the conversation and able to offer this level of assistance. But the appointer is still making the decision. There's no formal capacity assessment required, And whilst this is sent to us in the decision support service, it's not formally held on a register in the same way that applies with some of the other arrangements. And in the middle, the co-decision maker, again, comes about in the same way. Frequently, we're being asked already, how do I become my family member's co-decision maker? Again, we always say, well, what does your family member want? Because it has to be their choice. Again, the co-decision maker is somebody in a pre-existing relationship of trust, and together then they're putting decisions into a co-decision making agreement, which afterwards they're going to take jointly. Quite a bit more is informed procedurally. The Act is fairly detailed at this point, and you can see why it would need to be. These are important legal binding arrangements and care must be taken with them. So there are procedural requirements when they're sent to us for registration, and notice parties, other people are entitled to object and say, well, I don't think this person needs a co-decision maker, or it certainly shouldn't be that co-decision maker. And we have to review the position, listen to those objections and decide whether or not to register. One of the supporting pieces of documentation is a formal capacity statement from a medical or other healthcare professional. This was a change made in the amending legislation, so you don't need two, and they can be from either a medical practitioner or another healthcare professional named in regulations. The effect of registration then is that decisions included in that co-decision making agreement are to be taken jointly. They're not valid if they're not taken jointly after that point. So care should be taken with what goes in there. And then we hold that on one of our searchable registers that people will always know if you have a co-decision making agreement and that they're acting correctly and within scope of what you've agreed with them. And the co-decision maker reports to us and comes under our supervision so that we in the DSS can make sure it's all going well. And we would see it being our job to support the supporter, not to police them. They're ordinary people doing this because they're somebody that the person knows and trusts, and we want to make sure that that goes well. At the top tier then is the route to court and the appointment of a decision-making representative. So this could come about as an outcome of the review of those 2,200 approximately wards of court, or into the future they're going to be most likely the result of a Part 5 application, which is now to the Circuit Court. Wardship had always been the High Court, so the idea of the Circuit Court is that it will be more accessible, more cost-effective, and available on a regional basis. And it comes about when any person with a bona fide interest in the welfare of the person brings an application to court seeking a declaration about the person's capacity in specified matters. Again, moving away from the idea that you are a person of unsound mind. It's all about what you need to decide and when you need to decide it. And if the court makes a declaration that the person doesn't have capacity to make the particular decision, then that itself has to be kept under review. The court can make the decision for the person or appoint a decision-making representative, a DMR, and the court has to apply the guiding principles. The court has to think about the least restrictive thing to do, and the court has to think about what you want. So the court will look at the will and preferences of the person in making the appointment of a decision-making representative. And if there isn't anybody in the person's life who's available, suitable, and willing, the court can come to us in the decision support service. We have a panel of professional decision-making representatives, which we've been putting together over the last more than a year. So they are people from a social work background, from a legal background, and other professionals who are able to be nominated to the court and appointed by the court to do this job. But they have the same duties as an ordinary decision-making representative in the person's life if they are appointed. Again, the least restrictive idea, this should be limited in time and scope. It's not forever. It can be re-entered, varied, discharged, and it's held on our searchable register again so that people know that you have one. And any DMR who's appointed only takes their authority from the court order. Whilst they are an agent making decisions on behalf of the person, they still have that obligation to look to their will and preferences. And like the middle tier supporter, they're reporting to us and come under our supervision. There are things that they can't do. They can't make decisions about life-sustaining treatment. They can't prohibit contact by another person, and they can't. The Amendment Act removes any provisions in relation to restraint. We were quite keen in the DSS that any references to restraint by a DMR were taken out of this Act. So it isn't an Act which is about detaining or restraining. It's about supporting decision-making. There's particular provision for a minority of the wards of court who are presently detained. So of those 2,200 adult wards, we understand about 140 are currently detained by order of the wardship court in approved centres and in other locations. Like all of the wards, they're having their cases reviewed and will be out of wardship within 3 years, but their detention has to be reviewed as soon as possible after commencement. So they should be at the top of the queue for these to be heard by the court after the 26th of April. And the court will direct an independent psychiatric report to look at whether or not there is a mental disorder as defined by the Mental Health Act. And it may direct ongoing detention, but would be subject to the same review periods as the Mental Health Acts. And if the wardship court finds no mental disorder, then it will discharge from detention. And I'll say a little bit as I finish about the inherent jurisdiction of the High Court and where that might come in there. I used to act as a legal rep before the mental health tribunals. I acted for wards of court as well. And there was an unfortunate practice. It didn't happen that often, but sometimes people would be brought in under the Mental Health Act, and at least then they had the protections of that act and the tribunal system. But if they were made a ward of court, as very occasionally happened, they were gone from the mental health tribunal system. It improved more recently where detained wards were having their cases reviewed and had better access to the court. But that won't be an option at all now, so that people will not be, moving over to be detained in wardship any longer, and those detained wards are coming out. But let's just look at the inherent jurisdiction of the court. So planning ahead, I won't dwell on this, but everybody should think about planning ahead by way of enduring power of attorney or advanced healthcare directive, which I'll come to in a moment. And EPAs, if anybody already has one under the 1996 Act, that is still a valid EPA. What is new with this Act is that the EPA document comes to us for registration and then for notification if it becomes required later. And under the Amendment Act, an EPA may not include treatment decisions. Treatment is the business of the AHD, and I know that other colleagues presenting here are going to say quite a bit about AHDs, but the Act restates the fundamental principle that treatment may be refused by an adult with capacity for any reason, even though that refusal seems unwise, not based on sound medical principles, even if the refusal of treatment may result in death. And treatment is an intervention done for any of these purposes, including mental health treatment. And the purpose of an AHD is to enable a person to be treated according to their will and preferences, and to allow healthcare professionals and those close to you know with certainty what your attitude is to treatment. So that a refusal of...
We're just going to swap interpreters.
Oh, thank you. I'll hang on. Yep. And so that a refusal of treatment in an AHD is as effective as if it's being made in the present tense. And you can, with this Act, name your designated healthcare representative. So this is another sort of decision supporter who's going to ensure that people know about and respect your AHD and is enabled to consent to or refuse treatment based on your will and preferences. So that can include life-sustaining treatment. You can't refuse basic care in an AHD. So you can't say you don't want, for example, ordinary oral hydration, nutrition, or warmth or hygiene measures. It doesn't need to be registered to be valid. The Minister for Health owns this bit of the Act and may make regulations to provide for a register of AHDs to be held by the DSS, but those regulations haven't been forthcoming yet. And if there's any doubt about whether a person's AHD is valid or applicable, there is a process that applies and a route to court if necessary. And there are certain protections for healthcare professionals where perhaps they don't know about your AHD, or it's not clear, or they know about it but they can't find it. So there are certain protections built into Part 8. Exceptions in the 2015 Act, where there are exceptions, and these are based on whether a person is detained under the Mental Health Act and how they are detained. There was a broader sort of exception and it has been narrowed with the amending legislation. May I say that the DSS and the Mental Health Commission are on record as saying they don't like the retained exception, such as it is, even though it is narrow. But as I say, we won some arguments and lost others. So when it comes to AHDs, as you might know, a person can be detained under the mental health legislation on 2 grounds. There's the A grounds relating to risk to self or others, and B grounds where it's in order to obtain treatment and treatment is of benefit. So if you are, and the Act is worded in a slightly back to front way here, but to turn it back around, this is what it's saying, that if the person who has made their AHD is detained on the A risk grounds, then their AHD is not binding in relation to refusals of mental health treatment, but it shall be complied with in relation to the refusal of treatment of physical illness. And if the person is detained, but detained on the treatment grounds, well, then their AHD is as good as anybody's AHD. And at section 136 and consent to treatment, if a person is detained again on those risk grounds, then there is nobody authorised under the 2015 Act, so none of the new decision supporters are in a position to treat for mental disorder or consent to treatment for mental disorder. But otherwise, in other words, if you are detained on the B grounds, then references to consent in the Mental Health Act could include the consent of a DMR. So in broad terms then, an exception is being made of people who are detained on the 3A grounds, risk to self or others. And I'm sure that will come up for discussion, but in case it needs saying again, we didn't agree with that retained exception, but there it is. I will finish in a moment. So the DSS, we were going to be called the Office of Public Guardian. We were going to be in the courts service. The name changes were made in the journey up to 2015. And I think Decision Support Service is a better name. And I think the Mental Health Commission has been a better home. You will know that the Mental Health Commission has its other functions under the Mental Health Act to do with the regulation of acute services, and the running of the tribunal system. So it's been a compatible home, but we have our own separate functions under the 15 Act, broadly to inform and promote awareness of the new Act, to register the new arrangements and to supervise how they are carried out. And I'll come to some of those other functions in a moment. We'll also have panels of persons to carry out certain roles, so that panel of DMRs and panels of special and general visitors who help with our supervision and investigative functions. We have a particular duty under an international instrument called the Hague Convention, when there's a cross-border aspect to people's arrangements, and overall a duty to report back and say what's working and what's not, so that things are kept under review. I said how Ireland had retained a top tier of decision support, but with safeguards, and some of the safeguards would include our complaints and investigations function. Those are complaints about decision supporters and decision support arrangements, not complaints about service providers or other professionals. So when complaints, when decision support arrangements aren't going well, and sometimes they won't, we have a role to look into it, to investigate, to try to resolve it informally, but if necessary to escalate to court. And we can do that on an interim basis where things seem to be going so badly and so urgently wrong that we need to intervene to ensure that there's no loss or harm to the person. So that's our complaints function. Codes of practice will be published very soon, this month, we hope. There are 14 of them in total, providing guidance on an overall code on supporting decision-making and assessing capacity, guidance for legal, financial and healthcare professionals, and a particular guidance there in relation to advanced healthcare directives. And the status of any of the codes is that a person shall have regard to a code of practice when performing any function under the Act in respect of which that code provides guidance. Breaching a code doesn't give rise to any liability, but it's something that could be taken into consideration in other proceedings. So we hope that they will be valuable and provide general guidance. And we're publishing them together with your guide to the codes typed document. And there'll also be individual guidance in relation to some of the separate codes, but there'll also be separate guidance documents. So, for example, on how to make a co-decision making agreement, whereas the code is about how to be a co-decision maker. We don't make decisions for people in the DSS. We don't directly appoint decision supporters. We won't have a function to manage anyone's money or property. We provide information and guidance, but not legal advice. And we don't have a function, as I've said there, to regulate other professionals or services. So this is the last one from me then. I think this audience will be well aware of the potential challenges or matters arising. I suppose there's a challenge that is inherent in the fact that this is complex legislation. It is quite detailed, and I think there'll be an ongoing job to make sure that people have a good understanding of it and confidence in it. So our stakeholder engagement has been very diverse and it's ongoing, some of it in collaboration with Jacqueline and her HSE colleagues. And that won't stop on commencement. That's going to be an ongoing piece of work. I've said already, the 2015 Act is not about detaining people, and there is perhaps a gap at the moment in the protection of liberty safeguards have yet to be developed. They're an ongoing piece of work undertaken by the Department of Health. And in the meantime, the High Court has retained what's called an inherent jurisdiction, and we'll have to see how that is used. It may be that it is utilised to put people well effectively into a form of detention, because otherwise there's a gap. So we're watching that with interest. We have to ensure practical things, that costs, for example, are not a barrier to supports. And then, well, we're here to talk about it today, the interface with mental health legislation and the applicability in mental health services, and the amendments to the Mental Health Act are awaited with interest. And as I've said, it's very important that all of this is kept lively and agile and under review. It's so new, and we don't want to wait 151 years for a new piece of legislation if this needs to be tweaked, as we say. There we are. That is enough for me. I'm sorry if I've overrun slightly, Ber, but do please check out what we have available on decisionsupportservice.ie, where you'll find various guidance materials, explainer videos, frequently asked questions, and so on. And we're adding to that all the time. Thank you very much for your attention.
Thanks so much, Anya. You're so good. Thank you. And for anyone who's listening in and is hearing all of this for the first time, don't worry. There's loads of information online, and Jacqueline will be directing you to some of the other webinars. So I'm just wondering, Niamh, if you can spotlight myself and Barry there, and Anya, if you want to mute yourself and turn off your camera. And actually, just for Anya and Jacqueline and Fiona, if you see any questions in the Q&A function that you can answer directly, please go ahead and do that. Apologies I think there was some issues around viewing the ISL and the speakers. So we have the speaker and ISL, Sarah and/or Catherine, spotlighted. So for the recording, it should be okay. But we will, of course, review it afterwards. And if there are any issues, we'll make sure there are subtitles to go on. So apologies for, I think if people are tuning in on an iPad and a phone, it can be a little bit different. And just to say as well, if participants, if you raise your hand, unfortunately, we don't have an open conversation opportunity this morning. So if you can put your question into the Q&A box, please, or email me on bgrogan@mentalhealthreform.ie. Now I'm going to have a quick chat with Barry, who we were already trying to sort Barry's video this morning. So Barry, I don't know if you prefer to turn your camera off for the chat. I know we said Barry's the star of the show now this morning, but for some reason we haven't been able to fix his video. So if you just unmute yourself, yeah, so there's a lovely picture of you there, Barry, anyway, and hopefully you can see. Yeah. Thanks so much for joining us, and I know you spoke to Niamh last week, so I just have a couple of, I think 3 questions that Niamh had flagged with you that we'd have a chat about this morning. So the first one I wanted to ask you, Barry, was, so the Assisted Decision-Making Capacity Act will help ensure that the rights and wishes of people with mental health difficulties are respected and protected. As someone who has used mental health services in the past, why do you think this is so essential?
Well, it's essential because when somebody becomes unwell, for want of a better word, the authorities take over, and you have to do what you're told, basically. That's it. And I would not go that road again.
No. So you, do you have an advanced healthcare directive, or is that something that you have looked at before?
Not yet, no. But I would like to get an advanced directive done, yes.
Okay. And are there any particular things that you would add?
Well, three things actually. That number one, I would like to have a decision to appoint somebody to act on my behalf if they told me I was not well enough to make my own decisions, and that would be my daughter Kate, my first eldest daughter Kate. Number two, I would I would refuse to go into a psychiatric hospital. I would prefer to be treated in an ordinary hospital. Number one, that's number one. Sorry, yeah. The person first, then I would not go to a psychiatric hospital. I would not take psychotropic drugs. And also, mostly, I've had shock treatment before. I do not want it again, and I will not take it again. And that's it, basically.
Mm. Yeah, and I suppose I know Fiona is going to speak to us a little bit more about advanced healthcare directives. So, we know that people who maybe have been involved with mental health services and supports, who maybe have tried different treatments and medications, that people know best what works for them and the side effects and things like that, and should be involved in those decisions with the professionals. So are you hopeful that there's change happening, that from the 26th of April, we're finally going to have the Assisted Decision-Making Capacity Act?
Yeah, I am. There's just one other thing there. The only form of treatment I would take is psychotherapy.
Okay. And
yeah, I'm delighted with what's happening. Not alone for myself, but for other people as well, who, especially like down through the years, early, say going back in time, there was a lot of people put into hospitals for financial reasons, for another member of the family to take over something, So that's
yeah,
it.
and I think that's a really important point, Barry, because the Assisted Decision-Making Capacity Act, even though we're looking at it today mainly around mental health, it is a lot to do with financial decisions and housing. And I know Sage Advocacy have been running some information sessions as well around financing and banking and all of that kind of stuff. So I know it's a lot of information for people, but there is a lot out there already, and there are a lot of us who have been working in the background for years now, to try and get information out there and information sorted. And Barry, I know you had shared you very kindly agreed to last week with Fiona Morrissey to come and talk to us. And just for anyone else who's listening with lived experience of mental health difficulties, it's really important for us in mental health reform to hear and amplify your voices and your stories in whatever way you're comfortable with. So like Barry, if that's coming on and being, the movie star for the afternoon with the broken camera, or sending us in anonymous quotes, or taking parts in our surveys, we do have a grassroots forum of people with lived experience of mental health difficulties and of their family, friends, carers and supporters. And we are looking for new members of that forum. We're very conscious that it can be upsetting and tiring for people to consistently share their stories, or to maybe feel like, a tick the box exercise. And I'm thinking particularly of one brilliant woman who did a lot of work with us last year and over many years around assisted decision making and advanced healthcare directives. So we want to help support people to have their voices heard without putting any expectations or pressure on people. So we really appreciate Barry coming on this morning, and despite the technical difficulties. Barry, what I might do is, if you're happy at the end for the close, so after we hear from Fiona and Jacqueline, I might bring myself and yourself back if there's any closing comments from you at that point, if that's all right.
What time would that be roughly? Because I have to do something in the afternoon,
Oh yeah. Oh no, don't worry. We've to finish by 11:30 on the dot. So I think this is the start of a conversation for a lot of us. I'm hoping that everyone joined in today online, that this is kind of opening the doorway to conversations with us about this. So no, we'll be finishing by 11:30. I promise you. Won't keep everyone online for the afternoon.
Well,
great. Brilliant. So I might ask you to mute yourself there again, Barry. And what we're going to do now is, if Niamh O'Connor, our comms and member engagement manager, is also our super tech support this morning. So if Niamh could spotlight Fiona Morrissey, and we'll have Fiona's presentation now. So Barry, I'll just ask you to mute yourself again.
I have muted, yeah. Oh, sorry. Can you hear me?
I can hear you. Yeah, that's perfect. So we'll have Fiona. And just again to say, I know Sarah was supposed to finish up a bit earlier with us. So huge thank you to Sarah for staying with us a bit longer this morning and being a support for Catherine as well. So I'm going to shut up now and hand you over to the lovely Fiona, who hopefully the screen looks perfect from there, Fiona. So hopefully our tech issues are all sorted. I'll give you a shout in 10-15 minutes. That's okay. Thank you.
Thanks so much, Burr, and thanks to Burr Mental Health Reform for inviting me here today, and thanks to Barry as well for sharing his experiences there. And it was just really interesting to hear what Barry would like to put into his Advanced Healthcare Directive, because that's what I'm going to talk to you about today, about how Advanced Healthcare Directives are about respecting the wishes of the person, particularly in mental health. They work really well. And I suppose, you know, one of the things Barry mentioned there, ECT, and that was one of the most common things people put into an Advanced Healthcare Directive actually is their wishes around ECT in the mental health context. But just to say, first of all, that Advanced Healthcare Directives apply to all of us. So any of us at any time are vulnerable to not having capacity, to not being able to make decisions for ourselves. And that can be due to aging, it can be due to illness, physical or mental, or it can be due to an accident. And it's when we don't have that ability, to make decisions or able to communicate, that we're most vulnerable to being abused. And people who experience mental distress are actually 10 times more likely to be victims of violence than perpetrators. And they're particularly vulnerable to unwanted treatments and having their human rights violated. So their Advanced Healthcare Directives are very important in the mental health context because they provide that protection for the person against unwanted treatment. And also it helps respect the wishes of the person. So they're really important in this context. And some of you here today, and usually I ask at the start, is there anybody here who actually has an Advanced Healthcare Directive? And certainly if you do, just raise your hand or feel free to put it in the chat box, because you may already have one. And the new piece of legislation will just put into law that an Advanced Healthcare Directive is actually legally enforceable in Ireland. So just to kind of reiterate, I suppose, what they are in general, they're legal statements which allow you to outline your health or your mental health treatment preferences and to appoint a trusted person, i.e. a designated healthcare representative, as Anya mentioned previously. And that DHR can communicate your wishes when you're unable to do so yourself. So they're provided for in the Act, the Assisted Decision Making Act. Previous to this, their legal status was uncertain, and so you had no way of planning for periods when your decision making might be affected, whether it was because of your general health, your mental health, or could be end of life. So they only come into effect when you're deemed to lack capacity or you're unable to communicate treatment decisions. So they don't come into effect until that actually happens. And I suppose it allows people to write down who that trusted person is to communicate your wishes. So when you appoint somebody to be your DHR, they don't make decisions on your behalf. They make decisions in accordance with your wishes. So you will have discussed those with your DHR and you'll decide what powers you want to have given them. So an advance refusal of treatment, just to be clear, generally guarantees you will not be given the treatment specified. There are some exceptions, as Anya mentioned, but advance consent. So if you consent, like Barry said, he would like to have psychotherapy, that doesn't guarantee you will be given the treatment you've requested, because your requests aren't legally binding, whereas your refusals actually are. So an advance refusal, say, of ECT would be legally enforceable, where if you request something like psychotherapy, your wishes can be taken into consideration, but the law just says that, we can't guarantee that. And that's just down to a resource issue. And that's the same all over the world in terms of, the legal enforceability of advanced healthcare directives. So they work really well in mental health because many people have previous experience of treatment. And the focus is really on keeping the person well in mental health and the recovery. So in the end of life context, it's more about the person's end of life wishes, whereas in this context, it's more about keeping the person well and their own recovery. So it gives people control over their future treatment. It allows people to reflect on what works, doesn't work for them. It prevents the need, for future relapse, the need for readmission into hospital, and 63% of our admissions into the mental health system are readmissions. And it means that treatment that you do get will be based on your wishes rather than unwanted treatment or coercion. So there's better outcomes overall for everyone, people working in the system and the person. And, it's less traumatic, obviously, if the treatment that you get is in accordance with your wishes rather than something that's kind of forced upon you. So as Barry said, he might want a particular medication, maybe because of negative side effects in the past. So that might be something that you might want to put into your advanced healthcare directive. And many people actually put in requests for treatment. So there might be a particular treatment that worked for somebody. So you can put that in as well. And then you can put in something else maybe that didn't work so well for you that you might want to have again. So they work really well in that context, in the mental health context. And they work quite differently, I suppose, than, in the end of life context. And there's just an example there of a form on the screen. So this is just a template of what the parts of the form, what they might look like. So in that form there, you can see, you can specify what treatment I don't want to receive and the specific circumstances in which you want that refusal to apply. Now, if you want that refusal to apply, even if your life is at risk, you have to put a specific statement in relation to that. You can also put in specific treatment you would like to receive and the circumstances in which you would like that request to apply. And then you have to sign and date the form. It doesn't have to be on a form. There is a form being developed. But it's obviously better if it's on some sort of a recognizable template. That form has to be, or a template has to be witnessed by two people, one of whom is not a family member. And if you do have a designated healthcare representative, they have to sign it as well. So I suppose the legal requirements are there, regardless, but you don't have to use the actual form, but there will be one being developed. So why are they important? Well, they're important for all of us, as I said, because any of us could be in a situation where we're unable to express our wishes in relation to our healthcare or mental health treatment. And we're all potential users of mental health services. And the UN rapporteur, Danius Puris, this is what he stated in his report, his groundbreaking report in 2017. So any of us at any point in our lives can be potential users of mental health services. And if we don't plan ahead for these situations, someone will make those decisions for us. Our next of kin don't have that legal authority. So if we don't have a DHR or discuss our values and our wishes with somebody, what the treatment we get may not be in accordance with our values and wishes. So what AHDs or Advanced Healthcare Directives do is they enable us to have a voice in our own care. And they allow us to outline our statements, our preferences in a legal statement, and to appoint a trusted person if we do have somebody like that in our lives. So it's about respect for the voice of the person. So I suppose just in terms of yourselves, if you couldn't speak for yourselves, think about who would you trust, to communicate your wishes. Would it be a friend? Would your friends and family or your healthcare providers know what treatment you prefer? Would they know what you wouldn't want? So it's thinking about those sorts of things and starting to write that down. So this is something that you might do over a period of time. Not something maybe that you could do in one day. So you might take a couple of weeks to do this. It should be someone you trust and who's capable of making decisions on your behalf. So if you are appointing a DHR, it should be somebody you trust and you've discussed your wishes with them. So what does the AHD do for the person? I think Barry clearly articulated that there about what it would do for him. But I did a piece of research here in Ireland back in 2012 to 2014. And what people said was, in the mental health context, was that they would provide a sense of control in situations where people often felt they had no control. And people who had experienced involuntary detention in the past particularly felt that they had no control over what might happen to them again in the future should they become unwell. So I suppose the Advanced Healthcare Directive provides a peace of mind to the person. They enable the person to be treated in accordance with their will and preferences or their wishes. And so that's more likely to meet the person's needs and leads to better healthcare outcomes. Also, there was a review done of advanced healthcare directives which show that they reduce the need for coercive interventions or involuntary admissions or treatment by 23% in mental health. So that's a lot. So we don't have to treat people under coercion or under involuntary treatment. It's all obviously much better for everybody. So it's a forum, I suppose, for communication and for reflection. And a lot of people in my research, they felt that they weren't listened to. A lot of people just wanted the Advanced Healthcare Directive to have a forum where the wishes could be listened to and force people to actually listen and read it. So it increases that sense of respect and choice, and puts the voice of the person at the centre of the process. So these are some of the statements that people who participated in the research here in Ireland actually said as to what an advanced healthcare directive would do for them. So people felt it would make it easier to hear my voice, even if I am unwell. Just knowing the document was there provided peace of mind. And I thought this was particularly profound, that this person would said, I would finally feel safe. Even my advanced directive was legally binding. Is an awful feeling to know your liberty and rights can be taken away from you at any time, and you have no say whatsoever in your treatment. So that is an awful feeling to have, and the Advanced Healthcare Directive can protect against that feeling and have some control over what happens to you. I suppose in terms of healthcare professionals and families as well, there's a lot of benefits in that they increase the sense of trust. They also can enhance the therapeutic relationship. And I spent some time in the States where they're using them there for a long time in mental health, and they certainly have done that. So they provide important information, because a lot of us don't sit down and think about what we want and what we don't want, what worked for us in the past, what didn't work for us. And to actually have that forum, sit down and write that down and give it to people is very, very important. So also they reduce that decision-making burden on healthcare professionals and families, because now people know what the person's wishes are, so they can be treat and respect those wishes. So it takes the burden off someone else to make in terms of making decisions. So really, I suppose in terms of decision-making, it improves decision-making overall, because the person has reflected on what works, doesn't work, and they've communicated that. So there's better healthcare outcomes for everybody in terms of when the treatment meets the person's needs. Also in the research, people said it would mean they would be more likely to engage with services and treatment if they knew they had a legally binding advanced healthcare directive, because they knew they wouldn't be treated with something that they didn't want to have. So people are more likely to seek help if they have an advanced healthcare directive, and if they know that they're not going to be given unwanted treatment or subject to coercion. So generally, I suppose staff satisfaction is better where there's non-coercive responses. There's very few cases that actually they decrease litigation because they improve the quality of communication. So I suppose it's really an important communication and recovery tool as well. So it's critical, I suppose, the timing in terms of those conversations, because any of us, if we're in a crisis situation, that is not a good time to make a decision. So it's really important that you have this conversation, I suppose, when you're not in crisis, because often you don't think about these things until we actually are in a crisis, and we may be too distressed to make an informed or appropriate decision in those situations. So I think, a good time to have these conversations is when, you're in recovery or when you're not in a crisis situation, and that applies for any of us in any context. So there are some challenges with advanced healthcare directives as well. And, the international experience would suggest that they're not used very much. The usage rates are low because people find it difficult. It's like making a wheel, we kind of put it on the long finger. But I suppose in systems where, people are encouraged and supported to make them, they're used much more. So a lot of people felt they needed support to actually develop an advanced healthcare directive. So that might be sitting down with somebody like an advocate or somebody you trust, or it could be, a healthcare professional, and just talk to people about what you think you want to put into it. So people felt they needed that support. And in my research here in Ireland, a lot of people said they didn't have anyone they trusted to act as their their healthcare representative. So that's another issue, I suppose, particularly in mental health. 1/3 of people felt they didn't have a trusted healthcare representative who they thought they could appoint. You don't have to appoint a healthcare representative, but it obviously is better in terms of, respect for your advanced healthcare directive if you have somebody to actually communicate your wishes, as well as having it in a paper format. So you do need to have healthcare professionals buy-in for this to work. The best thing I say to people is for healthcare professionals to make their own advanced healthcare directive as well as the person that they're supporting, and that everyone has one. So it's not just for people who think they might need it. So who starts that conversation? Another, I suppose, big issue is this exclusion that Anya mentioned under Section 3(1)A of the Mental Health Act, where somebody's a significant risk to self or others, where there is an exclusion that their advanced healthcare directive is not legally enforceable in those situations. That doesn't mean that it still can't be taken into consideration. It can, but there is a possibility that it can be overridden in those situations. And I suppose we've done a lot of advocacy around this, and Burr will attest to that. But the group who need advanced healthcare directives the most are often, they're the ones that are being excluded from the legislation. But as I said, the exception, it has been limited more. But I suppose in terms of the mental health system, it can affect 100% of people being admitted for mental health treatment, because there's always the possibility of being regraded from voluntary to involuntary in the mental health system, or having the grounds of detention as changed if your advanced healthcare directive doesn't align with the proposed treatment. So people feel that exception needs to be changed, and there is a commitment to include that in the Mental Health Act, the amended Mental Health Act, and we will be, working on that. So we need more public awareness. It's important as well that you're able to access your advanced healthcare directive. So I know that there's talk of a registry, and there may be a register of AHDs, and also in terms of review, that you review it regularly. You change people, we all change our minds, so that you at least look at it at least maybe once a year, or particularly if you've had another crisis situation or change in your health status, that you review it and you change it and you say, does this still reflect what my wishes are? So we need, I suppose, a cultural shift in how we think about these. We need human rights training, and for them to be really effective. And as I said, the advocacy is ongoing. We will still be, lobbying for that exception under Section 3(1)(a) to be removed. The only circumstances in which an advanced healthcare directive in mental health can be overridden is where a person is a significant risk to themselves or others. So even if a person is involuntarily detained under 3(b)(1) and 2, their advanced healthcare directive is still legally enforceable. So I suppose 16% of our admissions to our mental health system are involuntary. So, it is a small percentage, and a smaller percentage of those are under 3(1)(a). Most people are under B1 and 2, but that doesn't mean that it doesn't affect everybody being admitted for mental health treatment, because you can be regraded very easily under the current mental health legislation. So we will be lobbying for that to be removed, and it doesn't comply with the UNCRPD. And just to say, one of the reasons that was included was because of risk, but in fact the evidence shows that there's no evidence of increased risk of violence in the general population, so that isn't a justifiable ground. And people actually rarely refuse all treatment in their advanced healthcare directive, so there's no reason that we need to keep that exception in there. But at the moment, I suppose the majority of people in mental health system will have legally enforceable advanced healthcare directives, but we still need to make that 100%, so that they're equally available for everybody, so that they are effective. So as I said, the advocacy will be ongoing, and I'm just going to leave you there with a quote from Nancy Hargrave, who took a case against the state of Vermont because her advanced healthcare directive in mental health wasn't legally binding. So Nancy Hargrave was a woman who had cancer, and she also had a bipolar diagnosis. And her advanced healthcare directive for her cancer was legally enforceable, but for her mental health treatment, it wasn't. So she actually won her case there, where, it was found to be discriminatory. So she said, it seems fundamentally unfair that I choose or refuse chemotherapy, which has saved my life. I don't have the same right to choose or refuse psychiatric medication. Now, thankfully, our preferences in relation to psychiatric medication is enforceable in most circumstances. We need to make that available for 100% of people in the system. So we will be ongoing with the advocacy in that. So I suppose advanced healthcare directives, they're affecting a cultural shift towards respect for the voice of the person. And they're really powerful communication and recovery tools, giving the person an increased sense of control and the need, make people feel more respected and valued. So it's about a cultural shift. It's not just about a legal document. It's about respect and control, and that cultural shift within our mental health system towards that. So they're really powerful tools in terms of that. So I suppose the first step for all of us is to start having that conversation around our wishes and values in relation to our healthcare treatment, and even who would we trust to communicate our wishes. And that can be in relation to our general health and our mental health. So you can have all of those in one document, or in separate documents if you wish, in your advanced healthcare directive. So it's a way to have your voice heard. And I suppose for people here who have lived experience, it's a way to have your voice heard. And I suppose for healthcare professionals, I would encourage you to have your own as well and to support other people to develop these. So I suppose an AHD is a small amount of work that gives a great amount of value in return. And when I went to Virginia, somebody said, you've nothing to lose and so much to gain. So thank you for that. And sorry, Ber, I think I might have run a bit over.
No apologies necessary at all. That's so great, Fiona. Thank you so much. And I do really hope that as we're going through the presentations that some of people's questions are being answered. And also in the meantime, there's loads of questions coming in through Q&A. So apologies, we're trying to get to them as we can. So we're going to have Jacqueline up now. So Niamh, brilliant. And just to highlight again that depending on your view on Zoom, you should be able to see the slide and also Catherine and the speaker, and that's what is been recorded. So, but as I said, we will double check that afterwards. So Jacqueline's going to give you loads of information now about all of the great work that's been done in the background on training and information. So Jacqueline is the project manager in the National Office for Human Rights and Equality Policy in the HSE. So again, I'm going to shut up now. So yeah, your screen is there. You just
perfect.
Brilliant. Thank you.
Yeah. Perfect. Thanks, Ber. And thank you so much for inviting me today. It's been an excellent morning so far, and I feel like I'm trying to fill lots of very big shoes by coming in at the very end of this. And I hope that the information I'm going to give you is going to be helpful for you in some way. So as Ber said, my name is Jacqueline Grogan. I'm Project Manager in the HSE National Office for Human Rights and Equality Policy. Our office was established in 2016 in preparation for commencement of the Act. Our office also has a number of other areas that we cover, including the HSE National Consent Policy, public sector duty. We do transgender and intersex rights. We also do some work around universal access for people with disabilities. So we're quite a busy office, but as you can imagine at the moment, an awful lot of the work that we're doing is around preparing staff and services for commencement of the Act.
Jacqueline, I'm so sorry. Could you just slow down just a little bit, just a little bit?
So sorry. It's the Scottish person in me. We all talk very, very fast. So huge apologies, Catherine. So what I'm going to talk to you about today is some of the resources and the work that our office has done in terms of providing information and resources for services and staff to help them prepare for commencement of the Act. Just to say that an awful lot of the resources that we've developed are also available on our website, so they're accessible to everybody and not just to staff, but some of them are very particular to staff as well. Just to say that the Decision Support Service also has a number of resources available on their website, and I know that kind of Anya would have given you their website earlier, and an awful lot of our resources kind of dovetail with theirs. So as I said, most of our resources are available on our website, which is on the screen there. Poor Catherine's going to have to try and spell this out now. So www.assisteddecisionmaking.ie. It's a bit of a mouthful, but most of our resources are available on that website. And as I said, that's publicly available to both staff, to services, and to people who use our services as well. So things that we have on the website include an explainer video. So it's a short explainer video that we produced back in 2015, 2016, which is all about what the Act means for me. And it's got a number of voices and people in the videos talking about why the Act's important to them, both people who use services and staff. And it's, as I said, it's only about 8 minutes long. And it's a really good tool if you happen to be kind of introducing somebody to the Act for the first time. There's also a short presentation on the Act, which is kind of similar to what Anya presented earlier, but slightly different, where you have me talking for about 20 minutes about what the Act is, what it means for practice within health and social care. And again, that's accessible to everybody off of our website. We have a number of frequently asked questions on the Act, including what does the Act mean when it refers to a relevant person? What does it mean for healthcare workers? And these dovetail with the FAQs that are available on the Decision Support Service website as well, so that you can kind of look at the two of them together. In 2020, in preparation for commencement of the Act, we hosted a webinar series back in early 2022, looking at a number of areas for staff in preparation for commencement, including things like how do you support someone to make a decision and the decision-making support arrangements under the Act, when to engage with the decision support service, positive risk-taking and unwise decisions, the functional assessment of capacity, and respecting the rights of the person and the roles of family under the Act. They're all recorded, and all those recordings are available on our website as well, and you can watch them back at your leisure. And there's a number of people who are in the room on the call today, I think, that would have participated in a lot of those webinars as well, and we've had some really good feedback on them. They're very much based on cases and particular situations that staff have found themselves in. So we based them on real life situations. So we found that that was a really good way of kind of conveying the information to staff. In November, we hosted a webinar on the transition from wardship to the Act, and I know that a number of people have asked questions about that in the Q&A function, so it might be worthwhile having a look at that. And that webinar had Anya Flynn and Alice White from the Office of the Wards of Court talking about what the change is going to mean for people who are currently wards of court, for committees of wards of court, and that transition into the Assisted Decision Making Act. So you can watch that back at your leisure. We also have a specific webinar that we hosted in November looking at the considerations for HSE mental health services in relation to the Act. And Burr would have been on that one and was absolutely excellent because she's a very engaging speaker, and Anya would have been there as well, who was equally engaging. But we also had kind of input from Professor Mary Donnelly from UCC and others about what the Act is going to mean in mental health services within the HSE. So we have an e-learning programme on HSE land, which is available to HSE staff and staff in HSE funded services. And the one on supported decision making in health and social care services is available already on HSE land. People can undertake that in their own time. There's 3 different modules within that e-learning programme, one on supporting decision making, one on planning for the future, and one on the functional assessment of capacity. We also launched a book back in, oh gosh, now that would have been 2020, 2021 probably actually, looking at personal and professional reflections on the Act. And this came out of a conference that we held in Cork in 2019. And the book has a number of short essays from lots of different contributors, talking about what the Act means for them. And it's a kind of thing you can dip in and out of. You don't have to read the whole thing at once. You don't need to read it in order. You can pick the sections that you're particularly interested in and have a read of the essays that are there. And that book is available on our website as well for free. So you can download the PDF and, as I said, dip in and out of it as and when you need to. We also produced a document on wardship applications, a guide for healthcare workers. So this is kind of before the transition to the Act and what staff should be doing in order to ensure that a person's will and preference is taken into consideration if wardship is being applied for. As Anya said in her presentation, we revised the National Consent Policy in 2022 and we produced a supporting e-learning programme for that, which is available on HSE land. There's a number of webinars available on our website around the consent policy, and there's a really powerful short video available up there as well on what is consent. And again, it's people who use our services talking about the importance of consent when they're going into services. What we did within the revision of the policy was we tried to emphasise the importance of the will and preference of the person, and aligned it with the guiding principles of the 2015 Act. Obviously, when the Act is commenced, we'll need to revise the National Consent Policy again in order to make sure that all the supports that are available under the Act are also embedded within the National Consent Policy, and that work has started already. In terms of things that we have coming up, we have a second suite of e-learning that's being launched this week and officially launched at the end of the month. And this one is about the Act. So it's particularly guidance for healthcare workers. So again, there's 3 modules in it. One is on the guiding principles. The second one is working with decision supporters. And the third module is on advanced healthcare directives. And that's available again on HSE land for staff and for people who are in HSE funded services as well. We have 2 upcoming webinars. The first one is on the 21st of March at 12:30, and that's all about getting ready for the commencement of the Act. If you're looking to register for that, I might see if Burr can kind of send the registration information out to the people who are in attendance after the events. You'd be more than welcome. And on the 29th of March, we're hosting another webinar, which is very much focusing on getting ready for advanced healthcare directives under the Act. And that's at 5:30 in the evening. And again, I can make sure that the information is distributed to people, to the people here. So there's some issues that kind of like, we would have spoken to a large number of staff and services in preparation for commencement of the Act. And there's a number of things that kind of come up regularly in terms of some of the concerns that people have. One of the big ones is that transition from wardship. So if you have a ward of courts and they're transitioning into the new arrangements, how is that going to work in practice? What happens if there's a concern about capacity? And I think Anya touched on some of that during her presentation. How do the court applications for the decision-making representatives happen? There's concerns about the scope of powers for enduring power of attorney and co-decision-making agreements. And Fiona would have given a very powerful presentation there on advanced healthcare directives, and she would have touched on this as well. There's concern by staff about the validity and applicability of advanced healthcare directives in some situations. Safeguarding issues and how they interact with the Act, and the whole transition from care representatives to decision-making representation orders under the nursing home support scheme. So these are some of the concerns that kind of come up when we've been talking to staff. But I'm also going to kind of give you a bit more information about some other considerations from health and social care. Like, the Act is very clear that healthcare workers should maximise the person's ability to make their own decisions. They need to provide information in a way that will best support the person to make their own decision, making sure it's in the right place and at the right time, using simple, clear English, trying to avoid medical terminology, the use of interpreters if they're needed, producing things in easy read versions if and when they're required, asking if they want somebody to support them, and also kind of giving things to people in advance so that they have time to read the information. But as many of you probably know, healthcare services are time poor. So there's a big piece of work that we need to do in terms of supporting the service in order to make sure that they're supporting the person adequately in order to implement the guiding principles of the Act. There's probably a need for some sort of a cultural shift within health services as well. We know that for decades, the health services have functioned under a medical model of capacity, where your person's capacity has been tested by things like an MMSE, where you're being asked who's the President of Ireland and to count backwards from 107s, which is one that I personally struggle with. So we need to kind of move away from that kind of medical model of capacity and kind of allow other kind of healthcare professionals in order to support people to maximise their capacity. We know that the presumption of capacity and the functional assessment are already in place in common law and practice, and that person-centred care and support should be the expected standard at the moment. But there is that need for kind of a bit of a cultural shift within services. And as both Fiona and Anya would have spoken about, that shift from next of kin as well to somebody who a person wants to be supported. The Act is very much about nothing about me without me. That's kind of the premise of this Act. It's about where this Act, the ethos of this Act as well. So it's about trying to make sure that the person is involved in all of their decisions about their medical care and treatment. But I suppose in terms of health and social care, and again, this has been touched on before, are we ready for will and preference? Particularly when will and preference isn't seen to be safe potentially. So the older person who's a falls risk, who wants to go back to their house, the person who wants to do something that's a risky behaviour. So what do we do when will and preference is no longer safe? There's a need for us to rethink risk within health and social care. And I think that was why we did that webinar last year, particularly focusing on the importance of positive risk taking and how that can be embedded in services. But as you can imagine, the health service is a very risk-averse culture. When we're talking to staff about unwise decisions within the Act, there's an awful lot of stuff about, well, am I covered? Would I be liable? What about families? Will the service throw me under the bus? And I think the scariest one of all that's on that image is, will I end up on Joe Duffy? But I think that we need to be rethinking about how we approach risk within health and social care services. And I think kind of following on from Fiona's presentation, one of the other questions is, are we ready for advanced healthcare directives in a situation where we're very much about treating and supporting the person? Are we ready for the doctor to say, yes, I'm going to follow what your considerations and what your rights are and what you want? I'm not going to talk too much about this because I think Fiona has covered it very eloquently in her presentation. So I just want to say, and I'm very conscious of time as well, but so I want to say thank you very much for listening to me. My email address is there if you have questions or queries. And as I said, I can try and get the information for the webinars to Burr, who can hopefully circulate them to the people who are here if they're interested in signing up for them. So thank you very much.
I'm on mute. Thanks so much, Jacqueline, and I love that you're giving me work there as well at the end of the webinar. Again, I just want to reiterate that I know this is a lot of information for people, particularly if it's the first time you're hearing it. But as Anya said at the start, you know, it's the end of April when we're looking at the law actually being operational and commenced. So there is plenty of time to get information. So actually, just before we come back for the final roundup, if you'll allow me, share my screen, and let me see if I can do this, if it'll work for me now. So hopefully everyone can see that. We decided to piggyback on the event with it being the 5th anniversary of Ireland's ratification of the UN Convention on Persons with Disabilities, to announce the publication of our new guide on effective public consultation processes for people with psychosocial disabilities. So the term used by the United Nations to describe people living with long-standing or enduring mental health difficulties is psychosocial disabilities. And this refers to the functional impact or barriers that those living with mental health difficulties experience every day. So the guide is aimed at government departments, statutory agencies and organisations in the public sector who conduct public consultations. This includes organisations delivering services in health, education, policing, as well as local authorities. And we've developed this guide to provide advice and information to ensure that consultation processes by public services are accessible and inclusive, or as accessible and inclusive as possible. And it offers practical information from different phases of public consultation, from the planning, design stages to implementation and evaluation. We would like to express our sincere thanks to the author of the guide, Audrey Dean, as well as the Disability Participation and Consultation Network and the Department of Children, Equality, Disability, Integration and Youth, who funded the project. Mental Health Reform is a member of the DPCN, the Disability Participation Consultation Network. And we would especially like to say a huge thank you to the individuals with lived experience of mental health difficulties who took part in the focus groups and contributed their invaluable insights into the project of the guide. It's going to be available to download later today, hopefully this afternoon, at www.mentalhealthreform.ie. And we will be printing a small number of copies, so people can email me if they want us to send them out. And as I mentioned at the start, you know, the presentations were sent out yesterday to help with accessibility. You know, it really is something that we all need to try and do better with, making everything as accessible and inclusive as possible. So I'm going to stop sharing and come back to the panel. Now I know we've 2 minutes, 2 minutes left. I just want to say again a huge thank you. There have been so many questions coming in that we've been trying to answer as panelists as we've been going along. Niamh, I'm not sure if you can spotlight us all there, the panelists. Just for, I know we had been asking for questions to be submitted in advance. So for people who did do that, I just wanted to note that we did receive them up to this morning, and there were some around, you know, when the codes of practice will be published, and as Anya said, hopefully that's going to be the end of the month. There has been questions about, you know, who's excluded, and I think there was a lot was covered about that, particularly people involuntarily detained under the Mental Health Act. And just to say, the people here today are not the government decision makers, and your local TDs, councillors, the senators in your area, they're the people that need to know that mental health is a voting priority for you and your family. They're the ones that make the final decisions. You know, Fiona mentioned advocacy and lobbying a lot, and that's a lot of what we do. Anya, in the committees, the Mental Health Commission, you know, we all spoke about the discriminatory exclusions, but the politicians really need to be hearing it from the people who vote for them. So I just want to, the Learning and Development Programme, I think Jacqueline, you covered that as well. So I'm not sure, was there anything else that came up in the questions that were coming in that anyone wants to address before we finish up?
Bar, I think you answered it actually. I hit done or something instead of send. I was going to answer one of them. But that's just to say, I think the very first question was about whether a parent or family member could become a decision-making representative. I think you dealt with it. Yes, of course, they absolutely can. And the court will have regard to existing family relationships in making that decision. And it's to be hoped that for the most part, anyone appointed will be somebody close to the relevant person. Can I say also, I think I just discovered a typo on my very last slide where I think I've got our own website address wrong. I'm sure people will have spotted it because I've spelled service wrong or something. But it's obviously decisionsupportservice.ie.
And I think I can send out links, and I can check with the speakers after if they're happy. We'll send out PDF versions of the presentations, and if someone needs them as a Word or PowerPoint for screen readers, just to let me know. But yeah, as I said, we've thrown information at you all this morning. There's so much already out there. As mental health reform, we're on the HSE's implementation steering group on ADM and on the mental health reference group. So we're linking in around frequently asked questions, documents, and things like that. So please do reach out to me. I'm very, very happy to be a point of contact for people to try and signpost in the right direction. And I promised I would. Barry, are you happy? And I know your screen was going on and off, but I don't know if you wanted to close off with anything there for us, Barry, or we'll have you back next time. Hopefully we'll be having something in person as well soon. Huge thank you to Anya, Barry, Fiona, Jacqueline, Catherine, Sarah, Niamh in the background, and for all of the prep that's been done, for everyone for engaging with us today. As I said, the recording will go up on the website. Please contact me on bgrogan@mentalhealthreform.ie or info@ and say send this on to Bear. The other thing just to mention is I think Inclusion Ireland are having an event next week as well around assisted decision making and people with intellectual disabilities. So there is a lot out there at the moment, and a lot of different agencies trying to get information out there. So please do try and get the information, and look to us if you need some signposting. So I think that flew in. Thanks so much, everyone. And yeah, we'll hopefully see you all soon. Really, really appreciate it. Thank you so much.
Okay, thank
you.
Take
Thank you,
care.
Barry.
Thanks, Barry. Thanks, Sonia.
Thanks,
Fiona.
Sonia. Thanks, Jacqueline. Thanks, Barry.
Thank you. Thank you, Catherine.
Thanks, everyone.